they decided to then go in and actually dispute it. So they want to stop this discovery from happening. So basically that's what we're going to look at next, is their documents and what they were filing. And then also Eric wants to do some discovery of WFG. He says, hey, you guys have information that we need for our case, so we would like to know about these particular things. We haven't seen the judge approve them yet. I think they just got filed a day or two ago. So we'll see what the judge has to say about that, but we don't have that information yet. So, oh, and then sorry, this is, if you're on the WCG side, you'll think this is funny, but if you're on GFI, you probably won't. I was going to use this meme originally. I don't know if I should use it or not, but I thought it was kind of funny. I felt like when they were asking the documents, it was kind of like the guy from Office Space. He's like, yeah, I'm going to need those text messages, phone calls, emails. Oh, and if you could give me a list of your corporate partners, your insurance agents, that'd be great. Okay, thanks, right? Kind of like that. If you come in on Saturday, we'd appreciate that. That's kind of what it felt like to me. I don't know. I thought it was comical. Maybe you don't. But let's look at the Olson's objection to what was filed and see what they have to say about the requests for that. I know I should have been a lawyer, huh, Roger? I appreciate that, brother. I should have been. I don't know, man. I can't do all this reading. Engineer is much better for me. I like math more than I like reading stuff, but somebody's got to do it. I appreciate it. Good to see you, Roger. All right, so let's get into the GFI discovery. All right, so this is going to be the first one that's coming from Eric. Deposition. No, let's see. This one's from Eric. Sandra and Joyner, they call them, so basically Sandra's filing most of this stuff, and then Eric's coming in and agreeing with it. So a lot of these documents are duplicated. I tried to get rid of most of them so we don't have to go through all the same stuff. So Sandra files it, and then Eric also files it, but we don't need to see both. They say basically the same thing. But basically what they're doing is they want to, they don't want the expedited discovery. This is their response to what WFG is actually requesting, okay? So the defendant, Sandra Olson, hereby joins in, and she's going to submit some exhibits A through C, which is what we're going to see here next, proposing what she believes or why they should not be able to get these interrogatories, their request for production, the subpoenas to third party, and information from the third party GFI. Moreover, the reason set forth in Mr. Olson's response that requires that she also be permitted to seek mutual discovery from WFG on the same timeline as WFG's expedited discovery. So here they're saying not only do we disagree with WFG being able to get more information, but we want information from WFG as well. So we'll see what is in there and what information they want from WFG and how much of a difference that might actually make. So those are going to be additional exhibits D through E, requests for production and special interrogatories for the court's consideration. We have not seen that to be approved yet or not. I'll let you know once that actually comes through. So let's look at those. Let's look at those exhibits, if you will, and we'll kind of go into what they're requesting. So this is Sandra. She's objecting to the interrogatories, so let's see what she has to say about that. So the first interrogatory, if you remember, they want identity of all current and former insurance agents of GFI, including the date when they first became insurance agents, right? We want to see, are you recruiting our people? And she says, this interrogatory seeks information that is not relevant to the alleged breach of contract based on the confidentiality and non-disparaging provisions, which are the only issues for expedited discovery could be relevant. The identity and contact information of all GFI agents might be relevant to the plaintiff's claim that Ms. Olson breached the non-solicitation provision, but the court did not permit expedited discovery as to this claim because the plaintiff failed to establish a likelihood of prevailing on this claim. Further, the court's bias for permitting limited expedited discovery was the plaintiff provided evidence showing the defendants used encrypted messaging services and alleged events unraveling rapidly, including the major conference that's coming up in Hawaii in March. The identity and contact information of all GFI agents has no bearing on whether these concerns, and thus forth, there is no reason to allow expedited discovery on this information. The interrogatory is overbroad, and it seeks to identify all GFI agents, even if the agents are not previously affiliated with the plaintiff. There is no justification for requiring Ms. Olson to provide the names and contact information of every GFI agent, regardless of whether they were previously affiliated with the plaintiff. Moreover, the plaintiff, WFG, did not name GFI as a party in this case. So basically what she's saying is that there's no relevance to why you're asking for this information, and why would you want information of people who never even came from WFG? And I think it still could be relevant information because you can do percentages, right? Like let's say of the 5,000 agents that came over, only 100 of them were from WFG. Well, that would be a great way to be able to tell, okay, you weren't really coming in and poaching. But if we come over and we go, okay, 4,900 of these were from WFG and 100 of them were new recruits, well, then we've got a different story. So they might still want, I could see why it would still be relevant information whether they were recruited or not, because you can start to see, okay, what percentage of your business came from WFG or not, but she's saying none of that's relevant and that they shouldn't have access to it. Finally, it would potentially violate the agent's privacy rights. They're worried about privacy rights now. Okay, so Ms. Olson, if she gave this information to you, well, then it's going to divulge their residential address, their last employer, business address, and titles. And so they want to protect their agents from having their personal information out. Okay, so number 2 that she's objecting to is identity and all confidential information, property that you or persons affiliated with you have retained your departure from WFG, identify a person of whom you have shared such confidential information or property with. So here's where we get into the whole Clinton argument of, well, what do you mean by confidential information, and what exactly is confidential, what should and shouldn't be there, right? And what do you mean by relationship? Like, what does that mean? So they're saying that the confidential information is too broad, it's vague. Confidential information is defined to include the identities and contact information of WFG insurance agents, unless such information became generally available to the public that resulted in a disclosure by the agent, any assistants, or any member of WFG's network, contractually affiliated agents. Thus, as defining the confidential information appears to include the names and phone numbers of WFG agents with whom Olson had previously existing relationships, or their family members and friends. This information is plainly not confidential, even if it was not generally available to the public. Similar, the terms persons affiliated with you is vague. What do you mean by persons? What do you mean by you? It's overbroad and burdensome, and it might require the Olsons to make representations about what other people did or didn't do. According to this interrogatory, should have been limited to Ms. Olson and not any non-public information that she took from WFG when she resigned. So we disagree with that. And by we, I mean Sandra's disagreeing with that. On the third point, identify all communications and statements made by you or persons affiliated with you or GFI about future ability to stay in business, its compensation structure, its opportunities pertaining to WFG. She says again, interrogatory is overbroad as to time because it purports to encompass communications during the time period that Olson worked for GFI before she quit. Such separation communications are not relevant to the plaintiff's request for prospective injunction relief. This is only which is the only basis for this expedited discovery. She gives some case law here that she's citing. So basically, you're asking for information before we quit. Well, I think that from WFG's standpoint, that's still important. Like, were you recruiting people before you even left? Were you telling them that you were going to be doing this? Did you have people who are kind of interested in coming over before you created the company? I think all of this is relevant as far as timeline goes and figuring out what's going on. So here they're talking about, in this particular case, It was declining to rule on claim that the employee had solicited other employees away from companies because the provision did not apply when employees no longer worked for the injunctive relief, which preserved the status quo. Any discovery relevant concerning past conduct should be obtained through standard discovery procedures under Rule 26 and should not be subject to extraordinary relief of the expedited discovery. Further, this interrogatory is broad to its scope, it's vague. The interrogatory seems to encompass every communication concerning WFG without any limitation to the subject of the communication. Indeed, Olson had told if Miss Olson told anybody that she was no longer affiliated with WFG, such a statement appears to be subsumed in this interrogatory because it concerns WFG. But I think that's fair too, and I think that if you weren't doing anything wrong, and I know you don't want to turn over any information, right? Any information that they get is going to be bad. But if you were just telling people, hey, I'm leaving, there's nothing wrong with that. You can do that. I think that would actually be helpful to your case. Just saying, hey, I apologize, I'm not affiliated with them anymore. I'm starting my own company. You can do that. The difference is how you go about doing that. Are you saying that WFG is falling apart and you're moving everything over and they're doing the wrong thing and you're defaming them on your way out? So yeah, I understand that makes it kind of broad, but I would think that you would want to turn that information over and say, hey, here's 500 of my guys that I communicated with, and I didn't say anything about recruiting them over. I just said that we have to leave and we're starting our own thing. There's nothing necessarily wrong with that. You can do that. So I would think that that would actually be beneficial for her, that she was mentioning WFG, but not in a bad light, just that they were moving over. But anyway, she's objecting to it. So the interrogatory then provides examples of type of communications it seeks, its future ability to stay in business, its compensation structure, its opportunities. But as phrased, these examples are in addition to all communications concerning WFG. Furthermore, examples themselves are vague. It is not clear what is meant by opportunity. What do you mean by the word opportunities? Nor is it clear. I'm sorry, I shouldn't be laughing. What communications relevant to WFG means. What do you mean by compensation structure? We don't know what you mean by these words, opportunity and compensation structure. So we need more clarity on that. Additionally, it is improper to require Ms. Olson to answer this interrogatory by including all persons affiliated with UNGFI. There are currently over 5,000. Okay, so we have a new update. It went from 4,000 to 5,000 now. 5,000 independent contractors. I think they're in what, week 7? Man, if they were recruiting 5,000 agents every 7 weeks in WFG, man, we'd be like 8 million people already, I think. So I wonder where they're coming from. So the independent contractor agents who work for GFI, this interrogatory would require counsel to interview 5,000 people to determine what they said at any time to any person as long as it pertains to WFG, and to summarize these statements and verified response. This would not be possible in the 30-day period that ordinarily applies to discovery, and certainly not the truncated schedule for expedited discovery. In any event, Ms. Olson should not be required to state under oath what each of these 5,000 independent contractors has stated about WFG at any point in their lives to any person. So again, it's that whole, what do you mean by sexual relationship? What is the definition of is mean? They're kind of fighting over that, the definitions, to get more clarity. So the fourth one that she disagrees with is the identity of any customer whom you previously worked with while engaged as an insurance agent with WFG, with who you or your downline have had communications with that left WFG, and state the nature of the contents of each of these communications. Her response to that is that the interrogatory is over, and if you don't know what interrogatory means, it's basically questions that have to be answered. That think of like an interrogation kind of, except for you can't waterboard people, but the judge makes them answer these questions whether they want to or not. So she's saying it's overbroad, it's vague, it seeks irrelevant information. The first clause appears to request Ms. Olson identify all customers with whom she previously worked while engaged with an insurance company, the list of customers Ms. Olson serviced during the many years that she worked with WFG, the relevant to issues for which the court is considering expedited discovery, and in any event, the information is clearly known by WFG. The second clause is more limited in its request to customers with Ms. Olson or any of her downline communication since she left. This cause, however, is overbroad, and there's no limitations to the identity, who initiated the conversations or the subject matter discussed. Thus, if the customer reached out to Ms. Olson, this interrogatory presumably requires this conversation to be summarized and stated in a response. There's no justification for such an overbroad interrogatory. Indeed, WFG has made no effort to limit the scope of this request, purported derogatory statements or use of confidential information, which are the only basis for which expedited discovery could be relevant. See, I think this would be a good thing too, right? Like if you were talking to your former customers, your former clients, and you were saying, hey, I apologize, I'm not going to be able to service this account, or I'm not going to be able to help you with that. Here's the people that you need to reach out to help with that. I don't know, whatever the case is, I think that would be a good thing to list. And you go, look, here's 100 clients that I reached out to, and I told them, I apologize, I can't help you with this stuff. I'm no longer with that company, but I started my own. I think that would be a good thing to show. What would be bad is if you had that same conversation, you go, that company's terrible, I'm so sorry, I didn't know these policies were bad that I wrote for you. You should really move these policies over with the new company if you want to stay with me, right? So how those conversations are happening are really important to determining fault in the situation. Then she goes on to say the over breath problems are compounded by the fact that interrogatory seeks communications by any agents of Ms. Olson's downline. And remember, this got sent both to Mr. and Mrs. Olson, so this is going to both of them. We're just not going to read all of them over and over again. But she says that these interrogatory refers to Ms. Olson's downline at GFI. There are currently over 5,000 independent contractors who work there. This interrogatory would require counsel to interview all of them. They cannot do this in the 30-day period. She should not be required to state under oath the substance of communications by others and all of their customers, regardless of the subject matter of those communications. So again, is WFG hitting on a point here? Are you churning all of these customers that are coming over? Because she obviously doesn't want this information to come, which I could understand would be burdensome to go talk to 5,000 agents, but I think an expedited way to do that is, okay, here's all the new clients that we had. Here's all the clients we had from WFG. Now you can see percentages. Okay, you had this many clients here and this many clients are now here. Well, obviously they moved. Were they canceling those old policies? They can go do discovery on that. You don't have to talk. I mean, I guess it is kind of broad in that you wouldn't necessarily have to talk to all of them, but you could just go in and see the client list and see which ones got converted. But anyway, I digress. So the next one that she's going to object to is going to be the production of documents. We'll kind of go through that. So they want all the documents, communications, and evidence of creation of GFI, its independent contractor agreements, and its registration. And she says that this request seeks documents that are not relevant, the alleged imminent breach of contract, and confidentially not disparaging provisions, which are the only issues for expedited discovery. Documents concerning the information of GFI have no bearing on whether Ms. Olson breached her confidentiality. So she's saying that they shouldn't get these documents because it doesn't pertain to the actual breach of confidentiality or the non-disparaging statement, which I think they could though, right? Because if she's evidence to the creation of GFI. So if you're talking to people about why you're creating GFI and it's in a negative light, then yeah, I think it could pertain. So further, the court's basis permitting limited expedited discovery, that the plaintiff provided evidence that defendants used encrypted services. So she's saying basically because WFG hasn't proven the fact that they were using Signal to send informations and then deleting them, that it's just that it's alleged and that they can't provide any evidence of it. So that's why they shouldn't be requesting more documentation, because they haven't provided evidence that that's even happening, although they have the statements from people like Bosley who mentioned that. But obviously you wouldn't have evidence of a platform that self-deletes. So I don't know. But I mean, it's a good argument to make if you can get the judge to side with you. I just don't see how that's really accurate. Documents concerning the information GFI to have no bearing on either of these concerns, and thus there's no reason to allow expedited discovery. The plaintiff seeking injunction against the Olsons, not GFI. In the hearing, they proposed the temporary restraining order. In this case, related to WFG action, or the Wyoming action, said that it would oppose doing so. So since they didn't grant the temporary restraining order, under these circumstances, the plaintiff should not be permitted or propound a burdensome discovery into completely sensitive information of GFI and its agents. She disagrees with having to provide all documents and communications relating to your possession of confidential information, but not limited to compensation structure, hierarchies, and contracts with product providers. Here she says, again, confidential information is overbroad and vague. Confidential information is defined to include these identities, unless such information can be generally available to a public. So this is kind of repetitive of what we've seen before. So basically she's just saying that we don't really know what is or is not confidential information. We don't want to turn over names and phone numbers of WFG agents or pre-existing relationships with family members or friends. This information is plainly not. So she's saying this information is not confidential. Oh my gosh, this is so frustrating. This is why I couldn't be a lawyer. Because in one breath, they're literally saying we can't turn over our agent's information to you because it's confidential information. And then right here in this sentence, they say this information is plainly not confidential. That giving you names and phone numbers of WFG insurance agents is information plainly not confidential. So like literally you speak out of both sides of your mouth. Either it's confidential information or it's not. You can't use it on both sides and say that, well, we can't give it to you because it's confidential, but it's not confidential when we have the information. So anyway, further terms, we don't know what you or URRB. These are very vague, overbroad, and burdensome because they are defined to include attorneys, investigators, agents, consultants, and other representatives. This would require them to make representations about what other people did or didn't do and obtain documents from third party. This problem is further exacerbated by the terms agents. We don't really know what the word agents mean. We don't know what you means. And so all of this is constructed to include the 5,000 independent contractors that they have. We would not be able to do this in a 30-day period because we cannot collect and review all the documents that they have and then verify that and have them attest it. We can't do that in a 30-day period. And it's certainly not able to do it in the expedited schedule of expedited delivery. In any event, she should not be required to collect any of this information. Accordingly, this request to be limited to Ms. Olson and any non-public information that she took from WFG when she resigned. So she is willing to turn over this information. Okay, how does she disagree here? The documents and the communications of all statements you made or caused to be made about WFG, its compensation, its business practices, its financial viability, its opportunities, its leadership, and its independent contractors. So what did you say about all these people to entice people to come over? Again, this request is overbroad as to time because it purports to encompass communications during the time period when Ms. Olson worked for GFI before she quit. Such pre-separation communications are not relevant. The request for prospective injunctive relief, meaning she wants the judge to come in and say to limit these time frames so that she doesn't have to give up discovery from beforehand. She cites some site code here from other companies. Any discovery relevant concerning to past conduct should not be obtained through should be obtained through standard discovery procedures under this rule and should not be subject of the expedited discovery. Further, this request is overbroad to its scope and it's vague. This request seems to encompass every communication about WFG, right? We kind of went through this already, so basically she's saying that she doesn't want to have to go in and talk to all communications about business practices, about financial viability, opportunities, independent contractors. Phase this example, this is kind of tough. You also want us to do this for 5,000 agents. You want us to go talk to all of these people. How are we supposed to know what they're doing and saying? We don't have any control over that. Sorry, those are my words, not hers. And to be able to collect all the documents reflecting such communications and provide verified response and to do all this in a 30-day period. It's certainly not truncated time schedule. We can't do that, especially on the shorter schedule of expedited discovery. According to this request, they're requesting that it should be limited to any reach of WFG insurance agents that occurred after she resigned, which she discussed with WFG and its compensation and all of those things. Plaintiff a fair opportunity to see what Olson did not take, propose confidential information, or make false statements. Okay, she's also does not want to turn over documents or communications reflecting evidence of your persons or behalf of communications of WFG insurance agents or their spouses in possibly becoming affiliated or part of GFI. And so her response to this is that this seeks information that is not relevant, alleges breach of contract based on the confidential and non-disparaging provisions, which are only issues for which expedited discovery. So this is kind of repeating itself again. We won't go through it all again. Even if it was permissible to conduct expedited discovery on the non-solicitation claims, this request is plainly overbroad because it includes communications with WFG insurance agents reached out to her, and includes communications with persons who are not WFG insurance agents or under any restrictive covenant with WFG, such as spouses, family members, or agents. Finally, terms you and your, they're too vague. It's going to become burdensome. You were made overbroad because of persons on your behalf. Thus, the representation of she doesn't know what other people did or didn't do to obtain documents from third parties. This is problem exacerbated again because there's 5,000 independent contractors, so she can't do all of that in a 30-day period. In any event, Ms. Olson should not be required to verify that she investigated, collected, and reviewed all third-party communications. Accordingly, this request should be limited to instances of Olson after she resigned, which she allegedly reached out to WFG agents, used confidential information, and made false statements in an effort to supposedly recruit WFG agents to GFI. All right. Then this is going to be her production of request for production to plaintiff. So this is what she's going to be asking for. So this is what they want back from WFG. Again, they're using all the same definitions. All right, so this is what Sandra and Eric want from WFG. So this is what they want as far as discovery goes. So she wants all communications about her and the litigation by WFG or any individuals who submitted declarations in support of the plaintiff's motion for temporary restraining order. So anybody who asked for a temporary restraining order, we want that information from them. Platform, but not limited to GroupMe, WhatsApp, Signal, Slack, through the present. So anybody that's had communication there. Produce any communications from WFG or the individuals who submitted declarations in support of the plaintiff's motion for temporary restraining order. So who was it that was involved in requesting the temporary restraining order? Did they talk to any of the leadership? Who was it that made those decisions? To current or former Pinnacle employees, independent contractors, or others concerning the restrictive covenant in their employment agreements, any potential litigation or adverse employment decisions in retaliation to their communication relationship or purported assistance to the defendants. So she wants WFG to provide all of that information. She wants them to produce all documents and communications related to your contention with that Sandra violated these particular sections of her agreement. We also want you to produce any documents or communications verifying your policies and procedures for terminating, disciplining, or divesting any employees, agents, independent contractors, workers, etc. for the violation of this particular agreement. So what are your actual procedures for these particular things? Basically, she's saying, well, maybe I wasn't terminated in the proper way. Is there a written thing that's supposed to happen? Do they get a warning first? Do they just get terminated first? Like, what is the proper procedure if you're disciplining somebody, if you're divesting an employee, an agent, or independent contractor, if you terminate them? What is the written procedure of what's supposed to happen? Maybe if they didn't go with that procedure, then that would help her case as well. So that could be some good information for her to get. All right, and then interrogatories. This is going to be the same thing. Oh, this is them. Identify any statements. This is the other information they want as far as interrogatories from WFG. So they want to identify any statements of Sandra that you contend violated these sections. For each statement identified in the interrogatory number 1, explain why you contend the statement violated the agent agreement. So we want to know exactly why were these people terminated. And they're doing the same thing for Eric as well, if you remember. So we're just not going through all of these documents because they're basically the same thing. But we want to know why. Like, how did we violate these particular sections? What did we do to get terminated? And then tell us why and how we violated each of these in that agreement. Identify all communications about Sandra and or litigations by WFG of any of individuals who submitted declarations in support of this motion for temporary restraining order, not limited to these things. Identify all communications after 2022 WFG or any individuals submitted declarations in support of the restraining order, employees, independent contractors, workers in California, concerning the restrictive covenants of this agent agreement. So they want to know those people as well. Okay. And then also GFI is against these things. So we're going to see what GFI has to say. Again, the beginning is just all the definitions. Sorry. And GFI, now, because remember, they're different entities. It's Eric Olson and Sandra Olson and GFI. So even though she's the owner of that company, it's still different in the eyes of the law. So again, they want all the documents and confidential information. GFI objects to any of this discovery. It's propounded by GFI. GFI is not the party in this action. Plaintiff is seeking injunction against the Olsons, not GFI. So you get to kind of play that game a little bit here too, where it's like, wait, this is against me, not my company. But there are lawsuits out there that talk about each of these. So this is why they ask them individually. So Mr. Olson proposed consolidating these cases, where related in the Wyoming action, which is kind of what they're doing. Wyoming is waiting for California to figure out what they want to do in this particular instance. So they're kind of holding off. So even if expedited discovery is permissible, GFI does not understand the confidential information. So this is going to be very similar to what we read before. What does confidential information mean? Is it generally available to the public? Is it a result of a disclosure? Is it part of the contractually affiliated agents? Which is funny again. Pre-existing relationships, friends or family members, this information is plainly not confidential, even if it was not generally available to the public. So again, names and phone numbers are now not confidential in this situation, but when WFG asks for them, they are confidential information. So moreover, terms you and your, we don't really know what those words mean. They're overbroad, they're burdensome, they're to define to include attorneys, investigators, principals, agents, officers, other consultants. It's too difficult for us to talk to all of the 5,000 agents and determine if they have confidential information as well, and collect and review all the documents and then have them testify under oath. Would not be possible in the 30-day period. Again, we've heard a lot of this. They also don't want to turn over the documentations and communications. The creation of your compensation, how did you create that? They're basically saying that this is, again, GFI is not party to this action. The plaintiff is seeking injunctive against the Olsons, not GFI. They cite some other code there. This request seeks documents that are not relevant contractually on the confidentially and disparaging provisions. They want it to be found in the regular discovery. They don't want to divulge its own confidential information, regardless of whether such information came from WFG or is based on their information. All the documents concerning the policies and procedures regarding the creation and the use of firewalls. GFI also, again, basically says that they're not party to this. That's the Olson's problem. It's not GFI, so we don't need to. We're hoping that the judge will say that we don't need to do this. Further, it's vague. It's overbroad. It does not define what a firewall is. We have no idea what that word means, even though we were giving them to people to sign, but we don't know what that word means. You didn't describe it. So is it limited to policies, procedures, practice regarding the use of firewalls or non-disclosure agreements as to the possession of WFG's confidentially? Does it only pertain to confidential information, or is it the use of firewalls and non-disclosures for anything? Like, right, thus as it's phrased, they seek information about any time that GFI used non-disclosure agreements for any purpose, including the safeguard of its own confidential information, which valid point here on their side. Okay, do they need firewalls and non-disclosures for the potential people who are involved in running the business and who are funding a lot of this stuff. If there's a non-disclosure there, do they have to turn that over? I could see that. That's a valid point in not wanting to turn that over. If that's not pertinent. I mean, it could still be, I guess, if one of those agents was formerly with WFG, or maybe it was a product provider. I know why WFG would want it, but I would know why they wouldn't want to give it up too. That makes sense. So they also don't want to give up all the documents and communications reflecting recruiting and communication efforts with other former WFG insurance agents. We don't think we should have to turn that over. Again, she's going to say that they're not party to this lawsuit, that it's between Eric and Sandra and not GFI. So they shouldn't have to turn over these information, a limited breach of contract. Same thing we're seeing above. Even if it was permissible to conduct expedited discovery on non-solicitation, this request is overbroad because it includes communications with WFG insurance agents, even if they reached out to her, and includes communications with former WFG insurance agents who are not under any restrictive covenant with WFG. So if they left, like I think they were saying Matthew Welsh left like 2 years ago. So if you talk to somebody from WFG who left 2 years ago, even though his spouse was with WFG, he basically turned the business over to her. I don't know why. If anybody knows why, let me know. But if you talk to somebody who was with WFG 3-4 years ago, do you still need to turn over that information? So they're objecting to that. Further, this request is vague, overbroad. We can't talk to all 5,000 agents. You guys get it at this point. Topic 1, the creation of GFI and its membership. Same complaints here. We shouldn't be part of this. The facts concerning the financing of GFI, including corporate banking. So who's giving you the money here? Who's backing all of this stuff? Do you have corporate sponsors? Is there a person or an entity that's helping you to do this? This could be a big thing if there's another company that potentially is helping them do this. They want to know who's involved in that. They're saying that, again, we're not part of this lawsuit. It's seeking testimony that is not relevant to the allegations of the breach of contract. So we don't want to turn that over. The facts concerning the creation of their compensation structure. How did you come up with this compensation structure? Did you design it specifically to recruit WFG agents over? You give them a little bit higher percentage up front, take it off the back end, so that way you're enticing people to come over, including its source and comparison. GFI objects to all of that. They say they shouldn't be part of this motion. The facts concerning the creation of GFI's hierarchies, including those carried over from WFG. GFI says that they're not subject to this, so they don't want to turn that over. Efforts to communicate with current WFG agents, including trainings. Like, are you putting on trainings for WFG insurance agents and then recruiting them to GFI? That you're directing towards them? Are you using social media? There's a ton of social media out there. Are you targeting emails, text messages, phone calls? Again, GFI is saying that they're not part of this. This is between the Olsons and WFG, so they shouldn't have to submit any of this as topic 6. It's not relevant to this breach, to the expedited discovery, so we shouldn't have to turn that over. But the court did not permit expedited discovery to the claim that the plaintiff falsely established the likelihood of prevailing this claim. So they're basically denying all of that stuff. So that's basically where we're at up until now. The judge has not given a ruling on what they want to do. It's incredible to start a new company on. Yeah. This one's funny. David, this was a good one, right? It's incredible to start a new company on the backs of so many illegal actions, right? And that's kind of why I started this, was I wanted to find out the truth, and unfortunately it's not looking good for the Olsons from what we're seeing in all this. And who knows, maybe in discovery stuff will come out and they'll find out, oh, they weren't doing anything wrong, they just created this new company and they're just fantastic recruiters. But yeah, it looks like if you're taking agents and converting clients, yeah, that's probably not a good thing. They weren't owners of their business, WFG, to find out Olson was doing all this sneaky stuff. Yeah, Leo, you're right. I don't know what happens, because I don't think WFG will let them come back. Because that was the whole thing of going to GFI, was that you would become an owner. And if you haven't seen that, I did a GFI contract. We went through and we read that together. And then we also read GFI's EMD contract, which was supposed to have all the ownership in it. So you can go see those